The reason 10 and 11 are back to back on this quiz is because I mixed them up when I took the principal test a couple months ago. There's a difference between an order placing a child with a non-responding parent or relative and granting custody to a non-responding parent or relative. So that's why they're in here like this. The order of placement can be combined with an order of supervision, an order for services, or an order of protection. The order granting custody to the non-respondent parent cannot be combined with any of those orders, except like an order of protection. But it cannot be combined with an order of supervision or an order for services. So I mixed that up. I don't want you to mix it up in case they repeat the question. What they did was they gave a scenario about Jack and Jane and something about like in an Article 10 case. And at the end of the Article 10 case, the way the judge handles it is that the judge grants custody to the non-respondent parent. And you had to know that no other order of disposition could be combined with the order granting custody. However, an order for placement with a non-respondent parent after an Article 10 case can combine with order for services and order of supervision. So with that said, let's review these two questions. 10 says, an order of disposition may release a child to a non-respondent parent or person who is the child's legal guardian at the time the petition is filed, which may be issued in conjunction with an order of supervision, an order for services, or an order of protection. The period may be for 1 year plus an additional year extension. Note these dispositions require progress reports be submitted by CPS every 90 days if the disposition was granted on consent of the parties and the child's attorney. Go to number 11. An order of disposition in an Article 10 case granting custody to a non-respondent parent may be combined with none of those. And that's what I got wrong, so don't make the same mistake. For 12, this is a 1021 question. If a child is removed from home on written consent of the parent, and unless the child is returned sooner, a petition shall be filed within 3 court days. So child is removed because the parent, ACS comes to the house, says, okay, this is no good, you're running a whorehouse, we want to remove the child. The parent gives written consent. A petition shall be filed within 3 court days unless the child is returned sooner than that. And then a hearing shall be held the next day family court's in session. So again, this is talking about on consent removal. So the removal is on consent, written consent. The petition must be filed within 3 court days, and then a hearing must be held next day, the next court day. Number 13, select the best answer. The court shall appoint an attorney for an allegedly abused or neglected child. And the answer is when a petition is filed or when the court receives notice of the emergency removal of a child or upon application of CPS for the removal of a child, whichever occurs first. So it's those 3 events, whichever of those 3 events occurs first, the court shall appoint an attorney for the child that's allegedly abused or neglected. Nothing to do with when the respondent appears in court or if someone asks. The court has to do it when the petition is filed, child is removed in an emergency situation, or CPS makes an application for the emergency removal of a child. For the emergency removal of a child. So if CPS makes the application, court appoints an attorney for the child. Which means, of course, that a lot of times when an Article 10 petition is filed and the child is removed, the child's already got an attorney because the court appointed it when CPS first asked to remove the child before a petition was filed. 14. A petitioner under Article 10, but Part 8, which is visitation of minors in foster care, is entitled to a court-appointed attorney if such petitioner is indigent. And that is true. The only times that petitioners get attorneys is Part 8 of Article 10 and Article 8. So remember the 8s. 1089. A child over the age of 9, oh, no. I'm just going to read it as if it's true. The answer to number 15 was false because it's over the age of 10. So I'm going to read it as if it was true. A child over the age of 10 shall also be served with notice of permanency hearing at least 14 days in advance of the permanency hearing date. 16, 1093. Who may originate a proceeding to adjudicate a destitute child? And the answer is D, only a commissioner of social services. So, who may originate a 10C proceeding or a proceeding to adjudicate a child as destitute? The answer is only the commissioner of social services. Only commissioner of DSS can originate a 10C proceeding. And another thing you should know is that in 10C, watch Angela's video on this, the petition has to be filed the summons has to be issued the same day the petition is filed, or something like that. Just watch Angela's video on 10C. She has one. It's in Gigi's series. Yeah, so I threw this question in here because it really pissed me off that I got it wrong on senior court clerk exam. The way they worded the question was just saying, the time rules for a motion in an Article 7 case are whatever. And I got it wrong. The answer is 7 and 2. The only motion that apparently is described in Article 7 is a motion for reconsideration of orders. And the time rules for that motion, reconsideration of orders and rehearing, is 7 and 2. And I think most of the motions in GD are 8 and 2, but the motion for reconsideration of orders is 7 and 2 in that one too. Most of the motions in GD are 8 and 2, but the motion for reconsideration of orders is 7 and 2 in that one too.